Good day, Sir Santana, and to everyone watching. This is Group 2 and I am Delvo Alzen Marie. Let's start off our discussion, shall we? Title 13, Special Corporations, Chapter 1, Educational Corporations. Section 105, Incorporation. Educational corporations are the type of corporation that must be controlled by special laws and by the general provisions of this code. Section 106, Board of Trustees. Educational institutions are organized as non-stock corporation. Trustees of said institution shall not be less than 5 nor more than 15, given that it should be multiples of 5. Board of Trustees of these educational institutions shall classify themselves that 1/5 of their number shall expire every year unless provided in the AOI or Articles of Incorporation. Trustees elected to fill vacancies before the expiration of a particular term shall be elected only until the expiration period. Meanwhile, trustees elected to fill vacancies after the expiration of the term shall be incumbent for at least 5 years. Authority of said trustees shall be explicated in the bylaws. As for institutions organized as stock corporation, shall be mandated by the provisions of stock corporations. Composition of the board for non-stock educational corporation. The board of trustees shall not be less than 5 but not exceeding 15 and should be in multiples of 5 only, so either 5, 10, or 15 only. For stock educational corporations, the Board of Trustees shall not be less than 5, but also not exceeding 15, like in an ordinary stock corporation. Next is in Article 1, Board of Trustees, Section 1. Board of Trustees shall be elected at the first meeting of the members and every 2 years. The Board of Trustees shall be composed of 15 members, and each shall hold office for 2 years or until a successor has been elected and qualified. If, at any time, a trustee ceases to be a member in good and regular standing, he shall then also cease to be a trustee. Then in Article 4, Officers, Section 1, at the first meeting, the Board of Trustees shall then elect from themselves a set of officers consisting of a chairman, a vice chairman, a president, a secretary, a business manager, and a treasurer. The same persons may be elected into more than one office, provided that it is incompatible with one another. Now let's move on with Chapter 2, Religious Corporations. In Chapter 2, there is Section 107, Classes of Religious Corporations. Religious corporation is a type of corporation that can be incorporated by one or more persons. This may be classified as corporation sole and religious societies. Next is Section 108, Corporation sole. Corporation sole is formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder, or may be termed as clergy of a religious denomination, sect, or church. The purpose of it is, as a trustee, to manage the affairs, properties, and temporalities of any religious denomination, sect, or church. Now, if there is a corporation sole, there is also a corporation aggregate. Corporation aggregate is formed for the same purpose of a corporation sole. It consists of 2 or more persons. Next is Section 109, Articles of Incorporation. In order to become a corporation, the incorporator must file with the Commission Articles of Incorporation, setting forth the following. A. That the clergy who wishes to become a corporation sole. B. That the rules, regulations, and disciplines of the religious denomination, sect, or church are in accordance with becoming a corporation sole and does not forbid it. C. That such applicant in charge with the management of the property, affairs, and temporalities of any religious denomination, sect, or church. D. that any vacancy occurring in the office of the incorporator must be filled according to the rules, regulations, and disciplines of the religious denomination, sect, or church. And lastly, that the principal office of the corporation soul is to be established and located within the territory of the Philippines. And that's it for my part. The next shall be discussed by Ms. Bation Marissa.
Thank you for that introduction, Ms. Delvo. Now, moving on with Section 110, Submission of the Articles of Incorporation. In order for the corporation soul to be officially formed, the Articles of Incorporation must be submitted to the Securities and Exchange Commission, which is the government agency that regulates corporation. This section specifies that corporation sole incorporator, who can be the chief archbishop, bishop, priest, minister, rabbi, or presiding elder, must sign an affidavit or affirmation that the Articles of Incorporation is true. This must be done with a copy of their notary's commission, certificate of election, or letter of appointment. Once the Articles of Incorporation is filed with commission, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder will become a corporation soul, and all temporalities, estates, and properties including hospitals, schools, colleges, orphanages, and cemeteries that were previously managed by the incorporator will be administered by the corporation soul on behalf of the religious denomination, sect, or church for the use, purpose, and exclusive benefit. Next is Section 111, Acquisition and Alienation of Property. For the purpose of this section, alienation means selling or mortgaging corporation soul's property. This section states that a corporation soul can buy and hold real estate and personal property for its church, charitable, kind, or educational purposes, and it can also receive personal donations or gifts. The general rule is a corporation soul can sell or mortgage its real property with the permission of the regional trial court of the province where the property is located. This is done by showing that the application for permission to sell or mortgage signed by the incorporator acting as a corporation soul was made public or as ordered by the court, and that granting permission to sell or mortgage is in the interest of the corporation. But if, as an exception, if a religious denomination, sect, church, or religious society represented by the corporation soul has rules, regulations, and discipline regulating the method of acquiring, holding, selling, and mortgaging real estate and personal property, those rules will be applied and the court's intervention will not be necessary. Furthermore, any member of the religious denomination, sect, or church that the corporation so represents can object to such application of selling and mortgaging real property. Moving on with Section 112, Filing of Vacancies. This section specifies how and who can fill the vacancies in the office of the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church incorporated as a corporation soul. Section 112 states that on the accession to the office, the successor of the incorporator in a corporation soul will become a corporation soul and may transact business by filing a copy of the commission, certificate of election, or letter of appointment with the commission. And only during the vacancy in the office of the incorporator, the person or individuals authorized by the rules, regulations, or discipline of the religious denomination, sect, or church represented by the corporation soul to manage the temporalities, transactions, estate, and properties of the corporation will have all the powers and authority of the incorporator. Section 113, Dissolution. A corporation soul may voluntarily dissolve and settle its affairs by submitting a verified declaration of dissolution to the Securities and Exchange Commission, which must state the name of the corporation, the reason for dissolution and winding up, the religious denomination, sect, or church authorization to dissolve the corporation, and the names and addresses of the person who will be in charge of winding up the corporation's affairs. And once the commission approves the declaration of dissolution, the corporation will no longer be able to do business except for the purpose of winding up of its affairs. And for the last section of this chapter, Section 114, Religious Societies. This section explains how religious societies can form a corporation. Section 114 states that, unless it's forbidden by a higher authority, the Constitution, relevant rules and regulations, or church discipline, any religious society or religious order, council or district organization of any religious denomination, sect, or church may form a corporation to administer its temporalities or for the management of its affairs, properties, and estate by obtaining written consent and or approval of at least two-thirds of its members at the meeting called for that purpose. Then finally, with the Commission, the articles of incorporation that have been verified with the affidavit of the presiding elder, secretary, clerk, or other member of the religious society or order, council or district organization of the religious denomination, sect, or church. And the articles of incorporation that will be submitted to the Commission in order for the religious society to form a corporation must state that the religious society, religious order, council, or district organization is a religious organization of a religious denomination, sect, or church. That at least two-thirds of its members has given written consent or voted at the meeting to incorporate. That its incorporation is not against the law or against the Constitution, rules, regulations, or discipline of the religious denomination, sect, or church to which it belongs. And that it wants to incorporate to manage its business, properties, and estate. The articles of incorporation must also indicate the place within the Philippines where the corporation's principal office is to be established and located. And lastly, the names, nationalities, and addresses of the elected trustees, which must not be less than 5 and more than 15, and who will serve for the first year or for as long as the law of the religious society allows. And that's it for my part. The next shall be discussed by Estanislao Mark Vincent.
Thank you for that introduction, Ms. Bation. Now let's head on to the chapter 3 of this title, which is the one-person corporation. So all throughout the discussion, I will call one-person corporation as an OPC. So what is an OPC? OPC is a corporation with single stockholder. The first section under OPC is section 115. This provision states that the provisions under this chapter is only applicable for the OPCs. Other provisions in the RCC are applied suppletorily. Thus, those codes are applied only when there are insufficiencies in the provisions under this chapter. Next is section 116, which states that the incorporator must be of legal age. Also, the subject being managed by the trustee is what the trust statement refers to, not the trust entity itself, because trust entities such as banks and quasi-banks, pre-need, insurance companies, trust companies, publicly listed corporations, and non-chartered GOCC may not form an OPCs. Also, natural persons who are licensed to practice his profession may not form an OPC for the purpose of exercising his profession unless otherwise there is a special law provided, because special law prevails over general laws. Other than that, foreign natural persons may form an OPC, but they are not exempted to the minimum requirement capital. Also, they are subjected to constitutional and statutory limitations such as engaging in certain investment activities. Additional information is that the term of the OPC must be perpetual. In case of trust or estate, the term of existence must be coterminous in the existence of the trust or estate. Under the name of the trustee, the proof of termination of the trust must be enough to dissolve the OPC, while under the name of the estate, the proof of partition is enough to dissolve the OPC. Section 117. The general rule is that the OPCs are exempted from the minimum amount of the required authorized capital stock, unless it is provided in the special law. Moreover, at the time of the incorporation, there is no required portion of the stock to be paid off. Section 118 states that the articles of incorporation must contain the following. If the OPC sole stockholder is the trust or estate, then the names, nationalities, and place of residence of the trust, administrator, or other persons performing fiduciary obligations, and the proof of authority to act on behalf of the trust or estate must be attached to it. Also, the name, nationalities, and the place of residence of the nominee or alternate nominee must be stated and their coverage of authority and limitations. Section 119 states that the corporate bylaws are not required to be submitted. Section 120 states that the OPC must be stated below or at the end of the corporation's name as an indication that the corporation is a one-person corporation. Section 121 states that the single stockholder should be the loan director and the president of the OPC. Section 122 states that the OPC shall appoint its secretary, treasurer, and other officers necessary in the corporation within 15 days from the issuance of the certificate of incorporation. Also, the commission must be notified within 5 days from the appointment. Single stockholder may not appoint himself or herself as the secretary of the corporation. Instead, he or she may appoint him or herself as the treasurer of the corporation. Being the treasurer, he or she must give surety bond to the commission, which is renewed every 2 years or as often as may be required. Section 123 states that the responsibilities of the secretary are, first, keeping the records of the corporation. Second is notifying the nominee or alternate nominee of the death or incapacity of the single stockholder within 5 days when it happened. Third is notifying the commission with the same situation. Also, the names and contact details of the identified legal heirs should be attached to it. And lastly is make arrangements for the meeting of the nominee or alternate nominee and the identified legal heirs for 3 purposes. First is the election of the new director. Second is the amendment of the articles of incorporation due to the changes. And third is other matters concerning the situation. That's the 4 special functions of a secretary. The OPC may designate more responsibilities to the secretary as it may deem necessary. And that's it. We're almost done, so bear with us. The rest of the topic will be discussed by Quilondrino Gian.
Thank you for the introduction, Mr. Estanislao, and for the final part, we're going to discuss Section 124, all about nominee and alternate nominee. A single stockholder should designate a nominee and alternate nominee because if happen that the stockholder is dead or incapacitated and cannot perform his duties, the nominee will act as director and manage the corporation affairs, and in the absence of the nominee, the alternate nominee shall take the place. Section 125, the term of nominee and alternate nominee. If the incapacitated of a single stockholder is temporary, the nominee will act as director and manage the corporate affairs. Meanwhile, if the incapacitated of single stockholder is permanent, the nominee will manage and act as a director until the legal heirs of the stockholder is determined lawfully. The alternate nominee will act and manage the corporation affairs in the case of nominee's death, inability, and incapacitated. Section 126, change of nominee and alternate nominee. A stockholder may change its nominee and alternate nominee by submitting to the Commission the names of the new picked nominees together with their corresponding written consent. And for this purpose, the amended of Articles of Incorporation is not needed. Section 127, Minutes Book. A one-person corporation shall maintain a minutes book which should contain all actions, decisions, and resolution. Section 128, Records in lieu of meetings. In a one-person corporation, written resolutions dated and signed by the stockholder is sufficient in lieu of meetings. For all the reasons under this code, the date of recording in the minutes book shall be assumed to be the date of meeting. Section 129, Reportorial Requirements. One-person corporation must submit the documents within the period that required by the Securities and Exchange Commission. First is the annual financial statements that are audited by an independent certified public accountant and would be provided that if the total assets or total liabilities are less than 600,000 pesos, financial statements shall be certified by the corporation's treasurer and president under oath. Second is a report that consists of explanations or comments by the president on every qualifications, reservations, or disclaimer. Third is a disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder. Last document is the other reports that the Securities and Exchange Commission may require. Also, take note that the Securities and Exchange Commission may place the corporation under delinquent status if the corporation failed to submit the reportorial requirements 3 times consecutively or consistently within a period of 5 years. Section 130, Liability of Single Shareholder. Under this section, it pertains to liability of single shareholder. A single shareholder shall prove that the corporation is adequately or properly financed. If it happens that he cannot prove that the corporation is properly financed, he will be jointly or solidarily liable for the debts and liabilities of the one-person corporation. And in terms of the liability, the single shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. The principle of piercing the corporate veil applies with the equal force to one-person corporation as with other corporation. Section 131, Conversion from an ordinary corporation to a one-person corporation, wherein the single stockholder may apply for conversion into one-person corporation after he acquire all the stocks of an ordinary corporation and must submit the documents that the Commission may require. Upon the approval of the conversion, the Commission shall issue a certificate of filing of amended articles of incorporation that reflect the conversion. The one-person corporation shall succeed the ordinary corporation and be legally responsible for all the liabilities. Section 132, Conversion from a one-person corporation to an ordinary corporation. After giving the Commission proper notice of the conversion's facts and circumstances, as well as after meeting all other requirements for stock corporations under this code and other rules, a one-person corporation may convert into an ordinary corporation within 60 days of the occurrence of the events leading to the conversion into an ordinary stock corporation. Such notice must be submitted with the Commission. The Commission will provide and issue a certificate of filing of updated articles of incorporation reflecting the conversion if all conditions have been met. As same with what I said in Section 131, the ordinary corporation converted from a one-person corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. And we're done. Again, I am Quilondrino.
And I am Marissa.
I'm Mark.
And I am Alzen Marie. Thank you for listening.